Dengan izin Tuan Magistrat, saya Syaza Athirah bersama Neoh Shu Shyan, Amirah, Chong Wen Ni dan Gar Fe selaku peguam beliau yang tertuduh pada hari ini, OKT, Pak Jimin Pak Jamin, nombor kad pengenalan 030605095083, memohon Mahkamah Yang Mulia ini untuk meneruskan sesi mitigasi tertuduh. Sebelum memulakan sesi mitigasi ini, mohon izin Tuan Magistrat agar hujahan dan rayuan kami disampaikan dalam bahasa Inggeris. With the permission of this Honourable Court, before the court sentenced the accused, I hope and request that the Honourable Court can consider the mitigating factors that me and my co-counsel will present later. Your Honour, the accused was charged under Section 6 of the Dangerous Drugs Act 1952 and punishable under the same section of the same Act for the offence of possession of cannabis. Besides that, the accused was also charged with the offence of self-administration of drug under Section 15, subsection 1, paragraph A of the Dangerous Drugs Act. Your Honour, we can understand the seriousness of this matter, which one were committing a crime, Your Honour would impose a commensurate punishment. However, we would like to propose a more suitable sentences for reducing the punishment according to his difficult situations. We hope you can consider these matters in imposing the sentence. Your Honour, Pak Jimin has pleaded guilty to the charges that have been read. By pleading guilty to the charges, the accused not only saved the court with expenses of a lengthy trial but also saved time and conveniences of many, particularly the witnesses. This has been set out by Lord Justice Muhamad in the case of Sao Soo Kim against PP. With the permission of this Honourable Court, please refer to the case of PP against Sharitan Pacemutu, whereby the court held that the accused plea of guilty should be considered and often the sentence will be reduced to 1/3 to 1/4 of the total time that will be served. Therefore, I respectfully submit that the plea of guilty of the accused can warrant leniency in sentencing. Your Honour, apart from the above plea of guilty, I humbly urge Your Honour to consider the age of the accused in determining the sentence. For the information of this Honourable Court, the accused is 20 years old, which is considered as a youthful offender according to Section 2 of the Criminal Procedure Code. It has been laid down under Section 293 of the Criminal Procedure Code for a youthful offender. Firstly, the court may order the accused to be discharged after giving a stern warning. Secondly, the court may order the accused to be delivered to his nearest relative, which in the accused position, he may be delivered to his sister to execute a bond for 12 months of good behaviour. Apart from that, this Honourable Court also may order the accused to be whipped by a cane for up to 10 strokes. Besides that, the court may deal with the accused following the provisions under Child Act 2001 or order the accused to carry out community service up to 240 hours. Therefore, we kindly plead for leniency in sentencing considering the age of the offender.
Your Honour, with your permission and the benefit of this Honourable Court, I humbly urge the Court to consider the character of this accused. The accused can be said as excellent student as he completed his PMR examination with excellent result, which is 8 A's and 1 D. Unfortunately, after both of his parents passed away, he did not continue with his study. Not only that, based on what has been stated by his sister, the accused has strong interest and talent in business. This can be said as a good virtue of this accused, which ought to be considered by the court. As decided in the case of Melvani against public prosecutor, the court had reduced the sentence imposed on the accused based on the fact that he pleaded guilty and has a good character. Therefore, I respectfully submit good character of the accused ought to be considered for leniency in sentencing. Your Honour, I would like to submit for the court to consider the effect on the family of the accused, as he is the only living family members to his sister after both of their parents had passed away. He has the responsibility to take care of his sister as the sole breadwinner in their family. Considering his contribution as a food delivery rider and helping her sister run the Tom Yum Kimchi restaurant at night, they are highly dependent on each other to survive and sustain their living, and it will cause hardships to the family if he is to be sent to the prison. In the case of public prosecutor against Adrian Kyung Peng Yin, the court did consider the accused's contribution and support to his family members as an exemption to the imprisonment sentence upon the accused. Therefore, we kindly plead for leniency in sentencing, considering the hardship that will be caused to the sister, his only living family.
Your Honour, I respectfully plead for leniency in the sentence to be imposed on the accused, taking into consideration the mitigating factors of the less deleterious nature of the drug involved, which in this case is cannabis. In the case of public prosecutor versus Puteh Nordin and another, the court recognized that cannabis is comparatively less harmful than substances such as morphine and heroin. Additionally, Your Honor, I would like to highlight that the comprehensive report on cannabis published by the Home Office in England stating that cannabis is much less harmful than opiates, amphetamines and barbiturates. By highlighting these acknowledgements, it becomes apparent that cannabis is widely acknowledged as a substance with a lesser potential for harm compared to the other prohibited substances. Your Honor, apart from the above plea and in pursuance to this plea of guilty, I humbly urge Your Honor to consider that the quantity of cannabis involved in this case is minimal. That the quantity is merely 0.16 grams, indicating personal use rather than distributions. The limited harm caused to the society supports a compassionate approach. In PP versus Tia Ah Ling, the court recognized that drug quantity is a relevant factor in sentencing. Thus, I respectfully submit that the minimal quantity of drugs warrants leniency in sentencing. Your Honor, the court should take into consideration that the accused possessed the drugs for personal consumption only as well, without any intention to distribute or harm the others. The self-administrations of the drug caused no harm to the third parties. In the case of public prosecutor versus Muhamad Zafri bin Muhammad Yunus, it was established that the self-administrations of drugs leads to harm confined to the consumer alone. Therefore, we kindly request leniency in sentencing, considering the limited harm caused by the accused self-administrations for personal usage only.
Your Honor, it is a strict law that the health condition of the accused must be taken into account. Referring to the case of Pendakwa Raya versus Said bin Ali, the court took into account the accused's health, which suffered from diabetes, in deciding the appropriate sentence after the accused pleaded guilty to the offense of possession of drugs. In the present case, the accused is diagnosed with diabetes stage 2. This long-term illness makes him suffer, and eventually, the accused found out that taking cannabis would reduce his blood sugar level, which relieved him from the hardship of the illness. I must inform the court that the accused was only a drug addict who believed that taking cannabis would reduce his blood sugar level. Therefore, it is respectfully submitted that a drug rehabilitation order may be a more appropriate sentence than a custodial one. Your Honor, it must be emphasized that remorse after the commission of the offense is an effective mitigation. In the case of Kasavan Sendaram vs. PP, it has been laid down that the court will consider the positive steps taken by the accused, such as if the accused is an alcoholic or drug addict, had voluntarily attended treatment classes or counseling to overcome the problems that led him committing the offense. In the present case, it is undeniable that what the accused did was wrong and constitute a crime, but the accused is truly remorseful and had taken positive steps after the commission of the offense when his sister plans to send him to a private drug rehabilitation center and later get treatment on a voluntary basis at Clinic Cure and Care. We respectfully pray to the court for a sentence designed to help the accused to overcome his addiction, for instance, a drug rehabilitation instead of a custodial one.
Your Honor, apart from that, the court should consider a discount as the accused has also made an effort to reform himself since his last conviction. According to Zaitun Zarif versus public prosecutor, the fact that an offender who has a criminal record has tried to rehabilitate himself since his last conviction shall count as a substantial mitigating factor. Despite the accused was convicted under the same offense when he was 17 years old, the court shall consider that there is a 3-year gap between the last conviction and this present conviction. Your Honor, in R versus Glup, the court agreed that the sentence should be mitigated even though the gaps of crime-free life was only 3 years. Allow us to refer to the court of Sosainadan versus PP. The determining factors is that the accused did take positive steps to reform himself after the terminations of the last conviction, and wherein in present case, the accused in fact has shown his effort to rehabilitate as he passed the observations of the welfare department and helped a sister in running Tom Yum Kimchi restaurant. In conclusion, Your Honor, I humbly urge therefore this Honourable Court will take into consideration the mitigating factors that the accused is a youthful offender who is suffering from long-term diabetes illness. He pleads of guilty, character and behaviour, effects on his family, the natures of the offence, as well as the gap principle which the accused has made effort to rehabilitate. Lastly, I humbly seek your honourable discretion to consider our plea of mitigation. Your Honour, I also urge this court to give the minimum fine and release the accused with a good behaviour bond. Much obliged.